If you're thinking of moving jobs, what do you need to look for? What should you watch out for, Michael Bagram?
We at Bagram's Attorneys are very careful to watch when an employee moves from one job to another, and we advise employees and employers on what has to be done. Obviously, the conditions of service are the most important issues that you look at straight up front, and you ask for that on paper, written down, obviously with the job description, and obviously the expectations of the employer must be carefully outlined to the employee. Otherwise you're going to have fights right in the beginning. We look at issues such as pension rights, and we look at anything that goes with the inherent requirements of that particular job. And when we talk about inherent requirements, we talk about what is expected of the employer, what they need to produce, what they need to do in the workplace. Obviously, the conditions of service can be changed, and we don't want to have in a situation where we need to say that there's got to be a unilateral variation of the conditions of service. So it's better to look at it up front and make sure that there is an agreement, and make sure that the employer specifically outlines what they want from that employee. We at Bagram's Attorneys obviously have those problems when we have to go to arbitrations in due course, and the allegation is that the employee didn't provide what we wanted that employee to provide, or they didn't have the skill, or they weren't up to it, or whatever they might say as an employer, and that employer then needs to come and prove. They have the onus to show that that employee knew exactly what was expected of him and her beforehand, and that expectation is now put on the table and that employee can't produce, and that's a problem with the conditions of service. And obviously when an employer comes forward and says now we need to vary that condition of service, that has to be done by agreement. You can't have a unilateral variation, and that goes, for instance, for every other right that an employee has. You can't have that unfair discrimination. You can have, in certain circumstances, direct and indirect discrimination for fair reasons. For instance, if they now have to hit an employment equity target, then you might have to say that we are going to discriminate against certain employees for promotional purposes because they don't fit our employment equity program itself. And obviously it has to fit in with the inherent requirements of the job. And we advise employers on a daily basis that let's have a look at those inherent requirements and let's see if we've done the correct particular position. Obviously, we need to ensure that every employee that comes into the workplace knows that there is a retirement age, for instance. Either they've got a provident or pension fund which has a retirement age built into it, or there would be a policy on retirement in that particular firm, so that someone coming in at, for instance, at the age of 60 knows full well that by the time they reach 65 they're going to retire in that particular firm, and these ages obviously vary. Also, when people say in their curriculum vitae that they have particular experience, they need to be able to show that they have the experience, and that experience fits in with what is the inherent requirement of that particular job. So we carefully assess that as well. We find in many firms that people come in and then they have policies saying that, for instance, we don't want any political discussion. And political opinion could cause problems at the workplace, and especially now as we are in a country where there's lots of political opinion abounding, and we don't want to have those fights. Most companies have policies on maternity with regard to the pregnancy. I know that our Minister of Labour at the moment, and it's an unfortunate term, the Minister of Labour is talking about paternity rights, but we must know that maternity rights do exist. People are entitled to 4 months off for maternity, and it's normally unpaid, but you can have a look at the conditions of that particular company that might pay you. Marital status often becomes important in terms of how much travel can you do. We don't allow in certain companies, for instance, husband and wife to work together, and so it becomes very important to talk about the person's marital status. It's the same with religion, race, sex and gender. All those issues are something that are important to put up front. Put it down on your application, make sure that it's all agreed and that everyone is fully aware and au fait with the terms and conditions of a service.
Would a contract cover all those points? And is it expensive to come and talk to somebody like you?
It is not expensive, and it is a worthwhile exercise as a group of attorneys specializing in this particular area of labour law. It's very good to ensure that the dispute is stopped before it happens.
Michael Bagraham can be contacted at michael@bagraham's.co.za, email, or you can call him too. He's in the phone book.